Well, good day, ladies and gentlemen. Now we're going to move on to chapter 10. So, in some of your textbooks, the newer editions, chapter 10 is actually the homicide chapter. In my book, or in the second edition, chapter 10 is the criminal sexual conduct, assault and battery, kidnapping, and false imprisonment chapter. And then chapter 11 in the newer textbooks is that chapter, and chapter 10 would be homicide. I prefer to teach it this way. I would rather teach that. I would rather start out the crimes against persons, because this is what this is: crimes against the individual body and persons. I would rather start out with assault and sexual stuff first, because really when we get into homicides, homicide is nothing but a completed an assault that results in a death, essentially. So I'd rather learn about what assault is first, and then learn about the resulting crime after. So in some of your textbook, this is going to be chapter 11, but in the textbook I have, this is chapter 10. So this is just going to be let's call it the lecture on criminal sexual conduct, assault and battery, kidnapping, and false imprisonment. So that's what this lecture is going to be on. Once again, I'll remind you. Let me get the website. You know how I do every time. www.sagepub.com/LIPPMANCCL2 the number 2E. That is www.sagepub.com/Lippman CCL2E. And that CCL stands for Contemporary Criminal Law, and then the 2E, second edition. That's just the original book I taught out of, so I created my initial master outline from this textbook. So that's what I use to teach. Now, I make sure I'm current and up to date. I know they drop new editions of the textbook, and I always look at the new editions to make sure that the content I'm teaching is relevant. I normally don't talk about a lot of case by case stuff anyway, and if I do, it's just an example. It's just a regular example to give you an example of how the law may be applied. But I normally don't do a lot of case talk, at least book case talk anyway. If I do case talk, it's all about stuff that's actually happened in my career and cases that I can talk about anyway. So just remember that textbook. Like I said before, go to the website. You can go to the student resource portal or tab. You can go chapter by chapter doing flashcards. They have outlines so you can kind of study what's going on, learn the main concepts, and they also have quizzes. I can tell you that all the multiple choice questions I'm going to be using for my midterm and my final come from those quizzes, directly from it, and I did it on purpose. For one, I didn't feel like making up my own questions, because making up questions is pretty hard. These textbook companies, they have people to do that. I don't have the time. So I like to find good quality questions to use and to kind of give back to my students. So in this situation, I found good questions, and the questions where you can go find them as well. So it allows you to kind of be double tested. So I want you to get out there and do the work. That's all I'm asking. Go out there and study, and you'll do well. I'm not giving you anything. I don't want you to think, oh, boy, it's easy. He's giving it to us. He's a pushover. It's not being a pushover. It's just requiring you to go out and do some extra footwork. And I'm rewarding you for doing so. Because believe it or not, even though I just said that, a lot of people aren't going to do it, and guess what? People actually miss. Some people get bad grades on my midterm and my finals. So it happens. So that means no matter what I'm giving you, people still don't follow it. So it's all up to you. It's all about your effort. So let's go ahead and get to this meat. I know we've been talking about all these chapters, and we haven't got into defining laws yet. We haven't gotten into the nasty stuff. Well, ladies and gentlemen, we are here now. We're going to talk about the nasty stuff. So you get your stomach ready, get your ears ready. We're going to be talking about real crime. What you're going to realize is people do bad stuff to other people. There are criminals out here, and there are people who do bad things. And now we're in with chapter 10 and 11 or 11 and 10, depending on what textbook you're in. These are basically the crimes against the person, crimes that involve what would I say, violations of personal space and my personal autonomy, my sexual autonomy, and my right to live. So ending my life is a homicide. That's violating my personal space, of course. So this is the chapter where we talk about that stuff, the things that happen. So it's going to be pretty hard topics, but we're going to get through them. I don't want you guys to be soft. So it is what we're going to talk about, rape and sexual stuff, and I want you guys to be prepared for it. We're all adults here. So let's go. This is chapter 10 in my textbook, and some textbooks is chapter 11. If it is chapter 11, just go to chapter 11, and 10 is next. But this is the chapter on criminal sexual conduct, assault and battery, kidnapping, and false imprisonment. As an introduction, this chapter discusses the three categories of crimes against a person. And actually there's a fourth, which is homicide, but we're not talking about that in this chapter. But that is sexual violations, threat and infliction of bodily harm, restriction of freedom of movement. So next to homicide, sexual offenses are considered the most serious offenses against the person and are punished as felonies, even when the victim is not physically injured. This harsh punishment reflects the fact that non-consensual acts of sexual intimacy can cause severe physical injury as well as psychological trauma. Assaults and batteries and false imprisonment are typically misdemeanors that risk or results in physical injury. Kidnapping is considered a serious offense that places people in danger and was subject to the death penalty. It used to be subject to the death penalty under common law. Now let's talk about rape first. Hard subject. Let's start off with the hard subjects. At common law. Now, mind you, everything we talk about, especially when we talk about common law, and you've heard this when I've talked in other chapters, I want you guys to know that women and the way women are treated have come, it's come a long way, and so the law is always going to be reflective of the time in which it was created. So I want you guys to learn that these law itself does not exist in a vacuum. A law is made and cases happen, and they happen, and they are a product of the time that they exist in. So when we talk about a lot of common law stuff, women weren't necessarily treated as much less than property during the common law era. So as modern laws come and it has come along, and women have earned rights, that they deserve. Laws have changed. So a lot of times this stuff is going to sound a little bit chauvinistic and super old school, and some women won't agree. But it's what it was. So I have to teach the historical background before we go into what we talk about and what the law is in modern times. So rape, the common law of rape. At common law, rape was a capital offense, meaning if you're convicted of rape, you would be executed as a defendant. This was controversial because the penalty of death for rape was almost exclusively employed against blacks, particularly when accused of raping Caucasian women. So it's another thing about law. Like I said, laws don't exist in a vacuum. There's also that whole racism thing that America's been doing pretty well since its inception. That always infuses itself. It's a part of America's DNA. In 1977, the U.S. Supreme Court declared the death penalty for rape unconstitutional on the grounds that it was disproportionate to the harm caused by the rape. So it's essentially it violated the Eighth Amendment. Today, most states divide rape into degrees of seriousness that reflect the circumstances of the offense. And they also have crimes that aren't rape, but all like sexual assault and different things. So it's more than just rape now. The law of rape was rooted in the notion that a man's daughters and wife were his property, and that rape involved a trespass on a man's property rights. For a brief period of time, the common law categorized rape as a trespass subject to imprisonment and a fine. This notion of the wife as chattel is illustrated by the fact that as late as 1984, 40 states recognized a marital exemption that provided that a husband could not be held criminally liable for the rape of his wife. So there you go, ladies. Common law was a little bit barbaric. So the law of rape is no longer an expression of property rights, and today is designed to punish individuals who violate a victim's bodily integrity, psychological health and welfare, and sexual independence. The stigma and trauma that results from rape contribute to reluctance of rape victims to report the crime to law enforcement. Another factor contributing to the hesitancy of victims to report a rape is a lack of confidence that the criminal justice system will seriously pursue the prosecution and conviction of offenders. The reluctance to report rape may be most prevalent in the largely undocumented area of same-sex rape, which is particularly serious, a particularly serious problem in correctional institutions. The system is fairly effective in prosecuting real rape, and we'll talk about what real rape is. Real rape is a case in which the victim is attacked by an unknown male, like the crazy guy out here that's raping people, as they say, Bolo. Be on the lookout. Um, in these cases, the prosecution has little difficulty in demonstrating that the victim was forcibly subjected to sexual molestation. The greater challenge, however, is presented in the area of acquaintance or date rape. In these cases, the perpetrator typically admits that sexual intercourse occurred and claims that it was consensual, while the victim characterizes that interaction as rape. So essentially, there's no denial that there was sexual intercourse. It's just a matter of one person's take on what it was as opposed to the other person's take. So that's why it's so hard to prove. Now, with real rape cases, where the person's unknown, we know that it was unconsensual. This person running around, crazy guy holding up people with guns and knives and raping them. We know that was unconsensual. We find that guy, it's easy to prosecute, it's over. Date rape or acquaintance rape is harder because there's no denial that sex happened. They're like, well, we had sex, but she thought it was cool. I thought she thought it was cool. I thought it was consented to. So what's going on? Why am I here? And it ends up being very hard to prosecute because it's hard to prove guilt, and then it's also hard because it takes a lot out of the alleged victim. Because what ends up happening is, of course, to defend oneself as a defendant in a rape case, of course, not to go to jail for rape in a situation where you claim that the sex was consensual. How far would you go to prove your innocence? It gets to a point where the defendants are now putting on evidence of the alleged victims' sexual past and stuff like that. So we had to create rape shield laws to kind of keep a lot of that out of court. So, but we'll get to that. We'll talk about that in a moment. We haven't even defined the crime yet. The symptoms of rape trauma syndrome. Of course, remembering the event. The victim has nightmares and has to replay that through their mind because their body was violated. Now, mind you, at common law, rape could only be done to females, and we're going to get to the elements of we're going to define rape in common law in just a moment. Also, strong emotions. The victim may feel anger, guilt, and depression, and may be drawn to suicide in certain situations. There are also other psychological impacts. The victim can lose self-confidence and develop an apprehension that they will be attacked once again. They often fear trusting others and withdraw from friends and relationships. Then you have the physical symptoms. In addition to physical injury, victims suffer headaches and stress leading to physical illness. You also have pregnancies that result from rape. And there also is a threat of sexual transmitted infections or STIs or STV, what do you call them? Sexual transmitted diseases, STDs and STIs. Then there's also the self-medication. Some victims may attempt to find comfort in drug or alcohol use. So there's a lot of trauma that comes from rape that people don't always talk about. So it kind of gets swept under the rug. Now, what is the definition? Now that we've been talking about everything but the definition, what is the definition of rape, of common law rape? Common law rape is the forcible carnal knowledge of a woman against her will. Now, I know you like carnal knowledge. That's something they would have said back in the day on some common law stuff. Carnal knowledge means sexual intercourse, vaginal sexual intercourse with a woman. So vaginal intercourse by a man with a woman who is not his wife. That's what that meant at common law. Because remember, at common law, the reason they said not his wife is at common law a man couldn't rape his wife because that was his property. So he could do what he wanted to do with her. So the vaginal intercourse is required to be carried out by force or threat of severe bodily force or harm without the victim's consent. The common law rape law reflects a distrust of women, and various requirements were imposed to ensure that the victim was not engaged in blackmail or in an attempt to conceal a consensual affair or was not suffering from a psychological illness. Rape is an accusation Rape is an accusation easy to be made, hard to be proved, but harder to be defended by the party accused though innocent. There is a danger that a judge and jury would be emotionally carried away by the seriousness of the charge and convict a defendant based upon false testimony. Prosecutorial hurdles when proving rape. Of course, immediate complaint. The absence of prompt complaint by a victim to authorities was evidence that the complaint was not genuine. And I hate to say it, a lot of times rape cases are not immediately reported. The corroboration rule. The victim's allegation of rape required corroboration, evidence such as physical injury or witnesses that could corroborate. And corroborate just means prove, outside proof, someone else coming in to prove. Then there was sexual activity. The victim's past sexual conduct or reputation for chastity was admissible at common law back in the day as evidence of consent or cross-examination to attack the victim's credibility. So imagine how not wanting to, that would be an incentive not to go to trial and not to prosecute if you're a victim, because now your sexual book is going to be opened up to the public, and they're going to be asking questions about it. So no one wants to go through that in public in a trial. Then you have the judicial instruction. The judge was required to issue a cautionary instruction to the jury that the victim's testimony should be subject to strict scrutiny because rape is a crime easily charged and difficult to prove. Crucial evidence under the common law was a demonstration that the female victim did not consent to the sexual intercourse. The lack of consent was demonstrated through outward resistance. At common law, a victim was required to resist to the utmost in order to establish a lack of consent. This reflects a natural instinct of a very proud female to resist. Resistance to the utmost was not required when the woman reasonably believed that she confronted a threat of great imminent bodily harm that would impair a reasonable person's will to exist. In the mid-1900s, judges began to relax this harsh resistance requirement. Some courts required earnest resistance. Most courts required reasonable resistance under the circumstances, and other courts required that a female victim engage in that degree of resistance that is necessary to communicate her lack of consent to a reasonable person. It may be satisfied even by verbal protest. So what that means is no. No means no. So the resistance is not required. Resistance is not required under common law when a victim is incapable of understanding the nature of intercourse as a result of intoxication, sleep, or lack of consciousness, or even they can't consent technically. They're not able to consent technically because of their age. They're not at the age of consent. Another exception is fraud in factum, or what we call fraud in the nature of the fact. An example would be a case where a woman consented to treatment for menstrual cramps by a doctor who proceeded to insert a metal instrument. During the procedure, he withdrew the metal object and, without consent, inserted his penis. This was rape because the victim consented to a medical procedure and did not consent to intercourse. So that's what we call fraud in fact, or fraud in factum. Not an exception to is fraud and inducement, or fraud and inducement or consent to intercourse that results from a misrepresentation as to the purpose or benefits of the sexual act. So the example here would be a female consented to intercourse with a donor after being tricked into believing that the donor had been injected with a serum that could cure her alleged disease. This was not rape because the victim consented to the thing done and the fraud related to the underlying purpose rather than the fact of the sexual interaction. So what that means is the person actually consented to sex. In the other situation, they consented to a medical treatment and it ended up being sex without them knowing. With this one, they said, "Sure, I'll have sex," but they just got lied to about the purpose of the sex. So it's not rape because the sex was consented to in that in the fraud and inducement situation. Rape reform, of course, and that's where we have the rape shield laws. During the 1970s and 80s, a number of states abolished the special procedures surrounding the common law of rape. This included the corroboration and prompt reporting provisions of the judge's cautionary and the judge's cautionary instructions to the jury. Rape shield laws prohibited the introduction of evidence concerning a victim's sexual activity. So the only sexual activity or past sexual activity that's relevant in rape cases now is past sexual activity with the actual defendant. So the defendant can put forth evidence that, hey, we've had sex 8 times. It was never an issue. Now this time she's saying I raped her. Then it's allowed, but you can't say it's not allowed for a defendant to come in court and ask her questions about, well, she let Reggie hit. This person hit too. Why, how is it rape? She a hoe. And I'm just using that as an example. I don't want you to be out there saying calling people a hoe. But essentially, rape shield laws kept that out. Irrelevant testimony about a person or evidence about a person's female sexual past is not allowed. These reforms are justified on the grounds that rape trials have become focused on the sexual background and resistance of the victims rather than the conduct of the defendant. And that's who it should be about, the alleged conduct of the defendant. A number of states adopted new sexual assault statutes that fundamentally changed the law of rape. It's not just rape at common law anymore, it's other stuff that is included. These statutes typically incorporated one or more of the following provisions. Rape became gender neutral, meaning that a male or a female may be the perpetrator or victim of a rape. Degrees of rape. Several degrees of rape are defined that are distinguished by one another based on the seriousness of the offense. These statutes provide that involuntary sexual penetration is more serious than involuntary contact, and that use of force results in more serious offense than an involuntary contact or penetration that is accomplished without the use of force. Sexual intercourse. Sexual intercourse is expanded to include a range of forced sexual activity or forced intrusions into a person's body, including oral and anal intercourse, and the insertion of an object other than into the genital or anal opening of another. Some statutes also prohibit sexual contact or the intentional and non-consensual touching of an intimate portion of another individual's body for purposes of sexual gratification. So that now extends it to more than just sexual intercourse of any kind, but it's also sexual assault, being touched, being grabbed without consent, or having your sexual body parts touched without consent. Consent. Some statutes provide that consent requires free, affirmative, and voluntary cooperation, or that resistance may be established by either words or actions. Other statutes provide that physical resistance is not required. Several continue to maintain the traditional standard that rape requires force along with the absence of consent. Coercion. There is an explicit recognition that coercion may be achieved through fraud or psychological pressure as well as through physical force. The marital exemption. Remember, in common law, a husband could not be charged with raping his wife. A husband or wife may be charged. The marital exemption is now going away, meaning that a husband or wife may be charged with the rape of a spouse. Half of the states continue to recognize the exemption, where there is no force or threat of force, or some require a prompt reporting requirement. Others only recognize the marital exemptions where the spouses are not living together and are separate and apart. Oh, I'm sorry. Yeah, make sure. Okay. Um. All right. These statutes are have removed the barriers that have made rape convictions so difficult to obtain. All right, what is the impact of rape reform? Despite rape reform, prosecutions for date rape inevitably seem to return to the considerations of force, resistance, and consent. You have the Kobe Bryant case. The victim accompanied Kobe to his hotel room, and her alleged resistance was in question. Um, the victim also had engaged in sexual contact with other men immediately following Kobe. Additional modern innovation. Some courts permit victims to present witnesses on the issue of rape trauma syndrome. This expert evidence is intended to support the victim's contention that she was raped by pointing out that the victim's psychological and medical condition is characteristic of rape victims. In other instances, experts are employed to educate the jurors that rape victims often have a delayed reaction and that the jurors should not conclude that an individual was not raped because the complainant did not immediately bring charges of rape or was seemingly calm and collected following the alleged attack. All right, punishment in sexual assault. Sexual assault is typically divided into aggravated rape and simple rape. Aggravated rape requires serious bodily injury or death, or the use of threat to use a deadly weapon or repeated rape. The perpetration of the rape by more than one individual or a victim younger than the age of 10 and a perpetrator who is at least 18 years of age. Sexual assault includes the compulsion of another to participate in the sexual act without consent or through threat or coercion, or by placing the other person in fear of imminent bodily injury, or by the administration of drugs, intoxicants, as well as the sexual assault of a juvenile younger than 16 by a parent or guardian. So that's just where it is in modern day. Now we're going to talk about the actus reus, the act of rape, the actus reus of modern rape, the sexual penetration of the body of a rape victim by force. Three approaches. Common law was only genital copulation or genital, what we call vaginal intercourse. Um, Now it's been expanded to include anal and oral copulation. Um, Digital penetration and also includes digital penetration, meaning penetration with something other than a set, something else. Um, and penetration with an instrument as well as genital and anal or oral sets, sometimes punished as a form of sexual assault. Virtually all jurisdictions have adopted gender neutral statutes that provide that women as well as men may be perpetrators or victims of rape. Sexual penetration, however slight, is sufficient to complete the crime. An emission is not required. The essence of the actus reus of common law rape remains the employment of force to cause another individual to submit to sexual penetration without consent. There are two distinct approaches to force. Extrinsic force approach requires an act of force beyond the physical effort required to accomplish penetration. This ensures that the penetration is without the victim's consent. Intrinsic force approach requires only the amount of force required to achieve penetration. This is based on the insight that there may be a lack of consent despite the fact that the perpetrator employed little or no force to achieve penetration. Let's see here. Now you have other approaches to the actus reus of modern rape now. The force requirement may also be satisfied by threat of force or by coercion. Actual force in modern law rape is usually not required. There are two requirements. There must be a threat of death or serious personal injury. The victim's fear that the assailant will carry out the threat must be reasonable. Then also, the threat requirement is also satisfied where a public official threatens to incarcerate, arrest, or deport the victim of another. Where actor is armed with a weapon or any article fashioned to lead the victim to a reasonable belief that reason believes it to be a weapon. Let's see here. Some jurisdictions have extended the actus reus of rape to declare that it is criminal to use positions of trust to cause another person to submit to sexual penetration. This is like public servants, therapists, nurses, and clergy. It's that can be in some jurisdictions that's deemed as a rape. So that kind of their position of trust and what they promise or what they say they can do now becomes a substitute for force. It was not forcible compulsion for an adult guardian to threaten to send a 14-year-old girl back to juvenile detention home unless she submitted to vaginal intercourse and various deviant sexual acts. The court ruled that although the acts of the 63-year-old guardian were despicable, the young woman was not coerced into the sexual activity because she voluntarily made a deliberate choice to undertake a course of conduct that enabled her to avoid return to a juvenile home. May be convicted of other sexual assaults or statutory rape. Correct something. Force is not required where penetration is achieved through fraud when the victim is unconscious, asleep, or insane and is unaware of the nature of the sexual penetration. In these situations, a victim clearly is incapable of consent and the law finds rape. So it's not just where they don't consent, it's also where a person has sex with someone who cannot consent. In statutory rape, force is also not required where the victim is a juvenile. So that's why we call it the age of consent. In North Carolina, the age of consent is 16 years old. So what that means is having sex with someone less than 16 years old is having sex with someone who legally cannot give consent. Even if they said, yes, I want to do this, they legally that consent that they've given is not legally enough because they're underaged. In North Carolina, statutory rape is where the victim is less than 16 years of age and the defendant or the assailant is 4 years or more older than them. So if a person is 15 and the person they're having sex with is 19, and pretty much more than 4 years older than them, 4 years older than them or more, then that's enough. That's statutory rape. Now, mind you, there's no statutory rape is what we remember from the earlier chapters. It is a strict liability offense. It doesn't matter that the 14-year-old girl or that the let's say the 15-year-old girl looked like she was 18 or like she was 20, or that she even held herself out to be that age. It's just that it happened. So now let's talk about the mens rea of rape. At common law, it required that the male defendant intended to engage in vaginal intercourse with a woman whom he knew was not his wife through force or threat of force. There was no clear guidance as to whether the defendant was required to be aware that the intercourse was without the female's consent. The majority applied an objective test. It is a defense to rape that a defendant honestly and reasonably believed that the rape victim consented. A defendant who entertains a reasonable and bona fide belief that the victim voluntarily consented to accompany him and to engage in sexual intercourse does not possess that wrongful intent that is prerequisite to the conviction of rape by means of force or threat. This requires equivocal conduct, meaning that the victim's non-consensual reactions were capable of being reasonably but mistakenly interpreted by the assailant as indicating consent. Then we have the subjective test. It is a defense to rape that a defendant personally actually believes that an individual has consented, based on information that the defendant is given and what the defendant was subjectively believed. The Morgan case, and it's the common law. A married man invited 3 of his drinking buddies to his house to have sex with his wife. He assured the men that although she might protest, his wife enjoyed kinky sex, and this was the only way she was able to get turned on. They held down the woman while they took turns having sex with her. The men were acquitted of rape because, on their honest belief that the officer's wife consented to sexual intercourse. Wow, that's crazy. This holding may be based on the common law idea of a husband's property interest in his wife. Several jurisdictions do not recognize mistake of fact defense and continue to adhere to the view that a defendant's belief as to a victim's consent should not be considered in determining guilt. The Plunkett case. A physically imposing 29-year-old defendant intimidated and forced a 17-year-old woman who was a virgin into his house, where she fearfully cooperated in sex. The court ruled that whether Plunkett thought his victim consented is irrelevant if the state proved that she did not consent. Plunkett argued that there was insufficient evidence to show that he knew his activity was unconsensual. His conviction was still affirmed. This approach converts rape into strict liability. I think it should be considered whether or not the assailant knows that the person is not consenting. But that's just my opinion. Statutory rape. Common law, sexual relations with juvenile was not a crime so long as there was consent. This was modified by a statute that declared that it was a felony to engage in vaginal intercourse with a child younger than the age of 10, regardless of whether there was consent. This so-called statutory rape was incorporated into common law of the United States. Legislatures gradually raised the age at which a child was protected against sexual intercourse. Statutory rape is based on several considerations. First, understanding. A minor is considered incapable of understanding the nature and consequences of his or her acts. Harmfulness. Sexual relations are psychologically damaging to a minor and may lead to pregnancy or other things. Social values. This type of conduct is immoral and is contrary to social values. And then vulnerability. Sorry about that. My words tonight. The protection of females is based on the fact that males are typically the aggressors and take advantage of vulnerable and immature females. General rule. Statutory rape is a strict liability offense in which a male is guilty of rape by engaging in intercourse with an underage female. Underage meaning below the age of consent, meaning they can't give consent. Even if they say yes, it's still not a yes because they can't give consent. This is intended to ensure that males will take extraordinary steps to ensure that females are the age of consent. The strict liability element is sometimes viewed as unjust in the case where a woman is physically mature and misrepresents her age. One reform is to provide that defendants can offer a promiscuity defense and document that the victim has had multiple sex partners and can be presumed to have possessed the capacity and appreciate the nature of her act and to have knowingly consented to a sexual relationship. Another reform is to divide the offense into various categories as to provide for more severe penalties for sexual relationships involving younger women. A third approach recognizes that young women will engage in sexual experimentation and that statutory rape should not be a crime where the parties are roughly the same age or should be punished less severely. 45 states recognize statutory rape as a gender-neutral offense. Only 5 restrict guilt to only males. The Model Penal Code limits strict liability to sexual relations with women younger than 10 years old. In these instances, there is a little likelihood of a reasonable mistake regarding the victim's age, because someone that age is obviously that age. The Model Penal Code also punishes sex with a woman 16 or younger by a male at least 4 years older as the less serious offense of the corruption of a minor. Let's see, it's Garnet v. State. Okay, I'm trying to look at this case. Okay. Withdrawal of consent. So even when when an alleged victim gives consent, they can withdraw it at any time. Even if you've gotten past third base, as they say, and got the home plate and you're in there, and consent can be withdrawn, and it's both male or female. A man can want to stop, and the woman can want to stop. And at that point, it has to end. A person who initially consents to sexual penetration or sexual conduct is not deemed to have consented to any sexual penetration or conduct that occurs after he or she withdraws consent during the course of the sexual penetration or conduct. So what that means is they can withdraw consent anytime. Then we have rape shield laws. So if they say yes at the beginning, you start having sex, and then while you're having sex, they say no, that means you got to stop right there. It ends. That's what that means. Rape shield laws. At common law, the defense could present evidence concerning a victim's prior sexual relations with the accused, prior sex with other individuals, and evidence concerning the alleged victim's reputation for chastity. This is based on the belief that the jury should be fully informed concerning the background of the alleged victim in order to determine whether her testimony was truthful or was the product of perjury or of desire for revenge. The law continues to permit the introduction of evidence relating to sexual activity between the accused and the victim, but not anything else. An individual who voluntarily entered into a sexual relationship with the defendant in the past is more likely to have again consented to enter into a relationship with the accused. The defendant is entitled to have the jury consider and determine the weight to attach to this evidence in determining guilt. But it's irrelevant to bring any other sexual information that doesn't involve those two into the trial. Rape shield laws prohibit the defense from asking the victim about or introducing evidence concerning sexual relations with individuals other than the accused, or introducing evidence concerning the victim's reputation for chastity based on several reasons. Of course, it's harassment, and then, of course, it's not relevant. Rape shield laws do not prohibit the introduction of an accused's past sexual activity in every instance. Courts have permitted the introduction of the victim's past activity with others in those instances in which it is relevant to the source of the injury or semen or reveals a pattern of activity or motive to fabricate. In State v. Colbath, the defendant and victim were in a bar. The victim made sexually provocative remarks to the defendant and permitted him to feel her breast and buttocks and rubbed his penis. The two went to the defendant's place where they had sexual intercourse. The defendant's significant other arrived and assaulted the woman, who cried rape. Despite the rape shield law, the defendant's Sixth Amendment right to confront the witnesses against him required admission of evidence of the victim's conduct in the bar because it might indicate that at the time the victim met the defendant, she possessed a receptiveness to sexual advances. Then you have People v. Wilhelm. Another case. Courts upheld a ruling excluding evidence that the victim had exposed her breast to two men who were sitting at her table in a bar and that she permitted one of them to fondle her breast. The court ruled that the victim's conduct in the bar did not indicate that she would voluntarily engage in sexual intercourse with the defendant. And that also, even in the Kobe Bryant case, now that case never went to trial because it settled. But part of the reason it never went to trial is because there was evidence that would have been relevant about the sexual activity of the victim that same night that she had sex with Kobe Bryant. As a matter of fact, almost immediately after the sexual intercourse was had between her and Kobe Bryant, she had sex with multiple other people. So that would have come into play, and it would have been very relevant because, of course, she was accused. She's saying that there was vaginal tearing and all this stuff, and it was Kobe. But if you had sex with like more people right afterwards, and there's DNA from multiple people inside of you, then that would definitely be relevant. And then also, as a defense attorney, his defense attorney could have slid in that, hey, is it normal conduct for someone to get raped and then say, I'm going to immediately have sex with other people? That would have been a question to ask a jury. But that's water under the bridge now. Kobe's gone, so is what it is. And it's not really relevant now, but I bring it up because we're in the rape chapter. We're talking about rape shield laws. Let's move on from the tough stuff and let's get to assault and battery. Assault and battery, although often referred to as the same crime, they are in fact separate offenses. A battery is the application of force to another person. An assault may be committed either by attempting to commit a battery or by intentionally placing another in fear of the battery. An assault does not have to involve physical contact. An assault is the first step towards a battery, and that law takes the position that it would be unfair to hold an individual liable for both an assault and battery. So normally they merge. As a result, the assault merges into the battery, and the individual only is held responsible for the battery. An individual may not be convicted of both assault and the completed crime of battery. So the reason they can merge or they become the same crime is because battery is when you physically punch someone or touch someone. Assault is when you place that person in imminent apprehension or fear that the battery is going to take place. What do I mean by that? So if I come up behind a person, they don't know I'm coming, I smack them in the back of the head, or punch them in the back, or kick them in the back. That is battery, but it's not assault. If the person is facing me and they see me coming, and I place them, and they see the battery coming, and I kick them in the chest, that is assault and battery, and it merges because they were placed in apprehension that I was going to contact them, and I contacted them. So now the assault merges with the battery, and it becomes battery. Now, the crazy thing about it is in the court systems now, all you hear is assault. You don't hear battery, assault on female. So it essentially, even though it hasn't technically merged, we still pretty much call assault batteries assaults, and that's where it kind of ends. But we're going to learn it the right way in this class. An assault, like I said, as a result of the assault, let me see, individual may not, okay. Elements of battery. Physical contact. Battery is physical contact that results in bodily injury or otherwise or offensive touching. A contact that is likely to be regarded as offensive by a reasonable person, with an intentional purpose or knowing or reckless intent. So, in other words, the knowing and unconsented. So that's another thing. The unconsented and intentional physical contact with another person that causes bodily injury or offensive touching. Battery is not confined to the direct application of force by an individual. It can include causing substantial bodily harm by poisoning, bombing a motor vehicle, illegal narcotics, or an animal. It can also include offensive physical contact, such as uninvited kiss or sexual fondling. So it's not just that it has to cause an injury. It can also just be offensive and non-consented contact. So being touched when you don't want to be touched. Now, mind you, it's not what we call customary or incidental contact. Like, so someone steps on your shoe on accident or something like that. Because remember, this is a general assault and battery are both general intent crimes, meaning it's intentional. So for someone to commit an assault or battery, they have to do so intentionally. So if they do it by accident, it can't be a battery or an assault. Let's see. Not every physical contact is a battery. I just said that. There is implied consent in contact in sports, medical operations, incidental contact while walking in a crowded place, or when a friend greets another with a hug or a kiss. The law accepts that police officers and parents are justified in employing reasonable force. Reasonable force is also allowed in self-defense and defense of others. Aggravated batteries require serious injury, use of a dangerous weapon, or the intent to kill, rape, or seriously harm. And so battery by itself is a general intent crime. But when you add other things like it can be aggravated when it's battery with a dangerous weapon or battery with intent that now adds a specific intent. So it's the initial battery plus a specified intent for a certain result. With intent to kill or something like that. That now makes the battery, it's a battery plus a specified intent added to it. Then we have mayhem, which is another crime. When one deprives a human being of a member of his or her body or disables, disfigures, or renders it useless, or cuts or disables the tongue, or puts out an eye, or slits the nose, ear, or lip. Assault. Assault is an attempt to commit a battery or by placing an individual in imminent apprehension or fear of the battery. So an assault can't be committed unless the person knows that it's happening. And they're placed in fear, or not necessarily, I won't call it fear, they're placed in apprehension of the battery. The placing of an individual in imminent apprehension of a battery must be coupled with the present ability to commit the violent injury on the person of another. So if a person is 100 yards away and I do like this, like I'm gonna punch him, it's not assault, because the assault has to be coupled with the actual ability to carry out the battery. But if I'm right in their face and I do this, and they jump back, even if I don't touch them, it's still assault because I placed them in the apprehension of the battery. So with assault, you don't actually have to touch a person. You just have to do something to place them in imminent apprehension of an immediately possible battery. Aggravated by specific intent, who and what. With intent to murder or rape or rob, that's a specified intent. With a deadly weapon, that's what, or automobile, that aggravates it. Who, on an officer, on a government official, or on a woman if you're a male, that can aggravate it. Or a device designed to assemble or resemble a deadly weapon. So when assault and battery, when they're aggravated, they're either aggravated by specific intent, what they're aggravated by, what was used to carry out the assault and battery, or they're aggravated by who they're carried out against. Elements of attempted battery, or sometimes they call assault attempted battery. Elements of assault. First, there's intent. The attempt to commit a battery requires an intent or purpose to commit a battery. The intent, an attempt to commit a battery requires or an intent to commit a not larceny. Ooh, wrong crime. I'm tired, y'all. An assault requires an intent or purpose to commit a battery. The act itself is to take significant steps towards commission of the battery. Presentability, and you must also have the presentability. The present, not necessarily actual ability to commit the battery. The victim need not be aware of the attempted battery. So that's an attempted battery as opposed to an assault. But an assault, there is fear, that there is some type of apprehension that they must know that it was about to happen. Elements: place another in fear, apprehension. Intent: a purpose to cause the fear of immediate bodily harm. An act that would cause a reasonable person to fear or be in imminent apprehension of bodily harm. Words alone are not enough. They must be accompanied by a show of force. Victim: the victim must be aware in an assault of the assailant's act and possess a reasonable fear or apprehension of immediate imminent bodily harm. A threat may be conditioned on the victim's meeting demands of the assailant. All right, so we have the three equations for these crimes. So we essentially get three crimes out of this part. We have battery, attempted battery, and assault. Um, Battery is the unlawful bodily injury or offensive contact with another, which is done on purpose. Actually, it's done intentionally with intent. But the book says purposely, knowingly, or recklessly negligent bodily injury or offensive contact to another. Um, then you have attempted battery, intent to injure plus an act undertaken to commit the battery. So normally with attempted battery, that means you never touched the person, you just tried. So I remember with an attempted battery where the victim knows there's place in apprehension is not an attempted battery, that's an assault. Um, so with an attempted battery, that means the person must have had their head turned or couldn't see it. So that makes it a battery, an attempted battery. Now, an assault is an intent to place an immediate fear of battery, plus an act undertaken that places a reasonable person in imminent apprehension or fear of the battery. Okay, so that's the end of the assault and battery. Now we're going to move on to stalking. When a person on at least two separate occasions follows another person or places a person under surveillance, or any combination of these two acts combined with the transmittal of a threat of imminent or future bodily harm, or the placing of a person in reasonable apprehension that a family member will be placed in immediate or future bodily harm. It's aggravated when combined with the causing of bodily harm, restraining the victim, or violation of a judicial order prohibiting such conduct. So that's stalking. We won't talk about stalking that much anyway. I don't even know why it's in this chapter. Um, Cyber stalking. I also don't know why this is in this chapter, but it's here. It's transmitting a threat through an electronic device of immediate or future bodily harm, sexual conduct, confinement, or restraint against an individual or family member of that person. The threat must create a reasonable apprehension of immediate or future bodily harm, sexual contact, confinement, or restraint. That's cyber stalking. Now let's get to a crime that actually is a crime against the person. Is where those last two were just they were more like threats, but they weren't definite crimes of either directly to the person's body or confining the person in their movement. This, however, is kidnapping. Common law: the forcible abduction or stealing away of a person from his or her own country and sending him into another country. The Lindbergh Law: it prohibits the kidnapping and carrying of an individual across state lines for the purpose of obtaining a ransom or reward. Parents were excluded from liability. Parental Kidnapping Prevention Act provides for FBI jurisdiction when a kidnapped child is transported across state lines. The abduction of children by a parent or relative involved in a custody dispute is also the subject of specific state statutes punishing the relative of a child who takes or entices a child younger than 18 from his or her lawful custodian. Victims of Trafficking and Violence Protective Act um, of 2003 and the Protect Act of 2003 both combat the international sex trafficking industry. What's the criminal intent of kidnapping? Mens rea: an intent to move or confine the victim without his or her consent. What is the actus reus? The forcible movement of a person from one place to another. Um, this is satisfied by any movement, no matter how limited or how sufficient. So, if I move a person against their will from one room in a house to another, that can be kidnapping. Um, it is the fact, not the distance of the forcible removal, which constitutes the kidnapping. Where another crime involves moving the victim as a central step in committing that crime, the defendant is not charged with kidnapping and is only charged with the initial crime. Courts now limit the application of kidnapping statutes to true kidnapping situations and do not apply it to crimes which are essentially robbery, rape, or assault, in which some confinement or aspiratation occurs as a subsidiary incident. No longer thought to include lawful confinements or movements incidental to the commission of other felonies. For a movement to be considered kidnapping, it must be more than slight, inconsequential, or an incident inherent to the crime. Or the movement must meaningfully contribute to the commission of the primary crime by preventing the victim from calling for help, reducing the victim's risk of detection, facilitating escape, or increasing the danger of the victim, like use them as a human shield. Those are situations where a person can be charged with kidnapping with that crime that involves movement. This excludes movements undertaken as a result of lawful arrest, court order, or consent. A victim revoked consent where the perpetrator prevented her from leaving the automobile by displaying and threatening her with a firearm, ordering her to place her hands under her thighs, and taking her to his home where she was raped. The victim's movement was forced by means of instilling fear, where rapists falsely represented that he was a police officer and informed the 18-year-old victim that she faced arrest unless she accompanied him to the store from which she was suspected of having stolen merchandise. This kind of compulsion is qualitatively different than the defendant had offered to give the victim a ride or sought assistance in locating a lost puppy or any other circumstances suggesting voluntariness on the part of the victim. Some states follow the model penal code in reducing the seriousness of the kidnapping where the victim was voluntarily released in a safe place. So what is kidnapping? I know that was a lot. Kidnapping is the book's equation. It equals intent to detain or move or detain and hide without consent, plus the act of detention and moving or detention and hiding, plus through the unlawful use of force or threat of force. Now let's talk about false imprisonment, which is like the little brother or cousin of kidnapping, but it's not quite kidnapping. At common law, the intentional and unlawful confinement or restraint of another person. The mens rea. Mens rea is the intent to restrain the victim. Model penal code, where one, without consent, without lawful authority, knowingly restrains another person so as to interfere with his or her liberty. The detention must be unlawful and without the victim's consent. A restraint by an officer acting in accordance with the law or by a parent disciplining his or her child does not constitute false imprisonment. Consent constitutes a defense. Actus reus. What is the act of false imprisonment? Compelling the victim to remain where he did not want to remain or go where he did not want to go. The confinement may be accompanied by a physical restraint or by a threat of force of which the victim is aware. Confinement may also be achieved without force or the threat of force when, for instance, the perp locks the door. An individual is not confined because he is prevented from moving in one of several directions so long as he may proceed in another direction. Confinement also in moving a bus or a hijacked airplane. False imprisonment may overlap with kidnapping or with assault and battery or robbery, and several states have eliminated the crime. The difference between kidnapping and false imprisonment is that false imprisonment doesn't require movement. Kidnapping statutes that punish the confinement as well as the movement of a victim often provide that the victim must be secretly confined or held in isolation for a specific purpose or for a substantial period. False imprisonment, in contrast, requires a detention that may take place in public or in the privacy of a home and may be for a brief or lengthy period. It's aggravated where the individual restrains another under circumstances which expose the latter to a risk of serious physical injury. Now, Another instance of false imprisonment. Let's say if you have people driving in traffic and there's a person or people block traffic because they're protesting. And now this traffic is blocked and everyone is at a standstill and people can't come or go or can't back up and get out. In certain situations, at least from a civil standpoint, because false imprisonment is one of the is a crime that a person can also be sued for on the civil side. That can also be considered false imprisonment because you're now trapping people on purpose and they're not free to go, they're restrained. So that's just an example. The book's equation, false imprisonment equals restraint plus by force, threat, or force, or constructive force. So that's false imprisonment. I think that's it. So that is chapter 10 or maybe 11 in newer books. But that is the chapter on sexual rape, sexual assault and battery, and kidnapping and false imprisonment. Let's see. So that is the close of that chapter. So now we're going to move on to what will be chapter 11 in my book. We'll move on into where we talk about the homicides. So that's going to be a fun chapter. So you guys be good.